So welcome everyone to Landmark Chambers webinar, Planning High Court Challenges Session 3. We're absolutely delighted to see so many of you joining us today and hope that you'll find the presentations and discussion to be useful and informative. Please note this is the third and final session of this year's Planning High Court Challenges webinar series. And if you'd like to access the recordings and presentations of the previous two webinars, please visit the resources page on our website where you'll find them there. My name is Wigley KC, and I will chair the session today, joined by my colleagues James Maurici KC, Gwion Lewis KC, Sasha Blackmore, and Ben Fullbrook. James Maurici KC recently won Environment Planning Silk of the Year at the Chambers UK Bar Awards 2022, and his recent cases of note include acting for Doncaster Metropolitan Borough Council in their judicial review relating to the closure of Doncaster Sheffield Airport, and acting for the UK government in Communication C-150 before the Aarhus Compliance Committee, in which Friends of the Earth alleged that Brexit is in breach of the Aarhus Convention. Gwion Lewis KC specialises in planning, environmental and public law. He was appointed Silk in the 2020 competition. He was my Silk buddy in that respect. Gwion was counsel for the local planning authority, Snowdonia National Park Authority, for all stages of the Hillside litigation. And those proceedings came after Gwion advised the Park Authority that they could rely on the judgment in the Pilkington case to stop the developer from building houses authorised by an old planning permission. And he'll be telling you more about that in a moment. Sasha Blackmore specialises in public planning, environmental, EU and information rights law. She's on the Attorney General's A panel and is described in the directories as outstanding in her diligence and approach. She's accessible, approachable, and provides high quality, client-focused practical advice. She appears at all levels up to the Supreme Court and has extensive experience of judicial review proceedings, statutory appeals and planning inquiries. She appears regularly in the Administrative Court and the Planning Court and has done a number of important inquiries on viability and major environmental infrastructure cases, including defending the most recent environmental challenge to Hinkley Point and the recent environmental challenge to the major redevelopment scheme at Dover. Last but not least, Ben Fullbrook specialises in planning and public law. He has particular expertise in planning high court challenges, having appeared both led and unled in a number of significant cases, including in the Court of Appeal. He's also been instructed to appear at Section 78 local plan and DCO planning inquiries on behalf of developers, local authorities and interested parties. And he's the author of the book An Introduction to the General Permitted Development Order, published in 2021. So those are our speakers, and without further ado, we'll move on to Hillside. Gwion.
A very good morning to you all. It is a real privilege for me to be talking to so many of you this morning about the Hillside case. We all know the case has generated a huge amount of interest and commentary since the Supreme Court gave judgment earlier this month. What I would like to explore with you this morning is this: has all the reporting that we've read about the case, has that reporting been accurate? Is the judgment a huge clampdown on flexibility when making planning applications for complex schemes, or has that claim been somewhat overblown in the articles and some of the LinkedIn pieces that we've been reading in recent weeks? We will look at that together this morning. Great to see, by the way, so many of you who are familiar to me on the call. Those of you who are not familiar to me, welcome. I hope you find this presentation helpful. So let's start with a little bit of scene setting. Where's this lovely place? This lovely place is Aberdyfi in northwest Wales, not far from where I was brought up. And this is where Hillside all started. You can see there a beautiful area overlooking the coastline, the town of Aberdyfi there in the foreground. And the developer, in this case, essentially wanted to rely on an old planning permission to build up to some 400 houses on that higher land overlooking Aberdyfi. And by the time the local planning authority, Snowdonia National Park Authority, came to me in around about 2016 to seek my advice on how they were going to deal with this claim by the developer, the authority was firmly of the view that it needed to change tack, to change its strategy in how it had been dealing with the site in recent years. And it really wasn't sure how to do that, because the site had a very complex planning history, a huge amount of paperwork that I recall arriving in at chambers. And so there was a need to make sense of it all and see where the law, as then understood, was taking us. So, essential facts of Hillside. It's got quite a complex history, but let's focus on the key bits. 1967, that's when the relevant planning permission was granted. So we are talking about an historical planning permission in the true sense. A full detailed planning permission was granted by the planning authority at that time on the large site overlooking Aberdyfi for just over 400 houses. Key point to understand is that it was a detailed permission and a master plan had been approved as part of that permission, which showed the locations of the 401 houses and also the internal roads. And I'll show you exactly what that was imminently. By the time that the case came to me in sort of the mid-2010s, 41 houses had been built on the site to date. But again, key point to understand, none of those houses accorded with that detailed 1967 master plan. The vast majority of those houses had been built under later planning permissions that had been granted for parts only of the site. So you had the 1967 permission, which was granted for the site as a whole, the large area, and then you had subsequent planning permissions granted for only parts of the site. And in the mix also, there were some houses that were unauthorized. We couldn't link them to any particular permission, but they were immune from planning control through the passage of time. And another key part of the history which the Supreme Court picked up on is that there were roads that had been built over areas shown as being locations for houses on the 1967 master plan and vice versa, houses built over roads. So one bonus I hope I can give you, given that you've kindly joined this call, is I can actually show you in this presentation the master plan, an annotated version of the master plan that was at the heart of the Hillside dispute. So can you see, everyone, there's a red line boundary in the usual way showing the larger site. The faint red outlines within that thick red line, they show the locations of the houses and roads approved in the original master plan. And what you've got superimposed on that, I don't know if you can see my cursor, possibly not, but what you can see superimposed on that is towards the south of the site, some of the earlier houses actually built on the site. And you can make out, I hope, from that slide, that already some of those earlier houses were not aligned with the location and orientation of the houses approved in the master plan. But then from the mid-90s onwards, there was a spate of further smaller planning permissions granted for that area towards the northwest of the site. And you can see here, I hope, that the departures were pretty substantial from the underlying master plan. You can see that the houses were in different locations, different arrangements, different orientation, and critically also, again, the roads and the road arrangement for these houses was starkly different, particularly in terms of orientation from what had been approved. We can see roads going over the approved locations of the original houses going in completely different directions. This was the position, everyone, by the time that we came to court. And the developer's case, essentially, putting it very simply, is they were saying, well, look, we accept that we've carried out development on these parts of the land, but look at this vast area in the rest of the site. We haven't built any roads there. We haven't built any houses there that arguably conflict with the location of the houses originally approved. So why can't we go back and just build those because they've been approved pursuant to the master plan? A complicating factor in the Hillside case, as if we needed another complication, was that the matter had come before the court before. It had come before the court all the way back in 1987. I told you this case had a long history. In 1987, some 19 houses at that point, 19 of the 41 we have now, some 19 houses have been built under different permissions. And if I go back a slide, they were mainly these houses towards the south of the site. So there was a dispute then with the then planning authority at Gwynedd County Council about whether, having built those 19 houses in different locations, could the developer fall back on the 1967 master plan for the rest of the site. And the High Court in 1987 ruled that the developer could do that. It said the developer could rely on the 1967 master plan to build houses on the unbuilt parts of the site, because although there'd been some departures towards the south of the site, they weren't sufficient, said the court, to mean that the right to rely on the 1967 master plan in the rest of the site had been lost. However, and it's however with a big underline, however, the High Court, rather unfortunately, you might say, wasn't taken to any of the case law on inconsistent planning permissions that has, as we know, at its head, the Pilkington case, which I'm going to come back to and refresh your memories on that imminently. So just think about that. Quite a significant High Court case in Wales in 1987 that neither party, unfortunately, drew the attention of the judge, who wasn't, I think it's fair to say, a planning expert, did not draw the attention of the judge to the critically important case law dealing with this very issue. So the developer in 1987 felt vindicated, but again, progress in carrying out the development was extremely slow. We then are in the mid-90s, and then the new local planning authority, Snowdonia National Park Authority, grants further planning permission for small groups of houses in that northwestern part of the site that we were just looking at. And it did so, didn't seek to relate any of those planning permissions to the wider permission, the 1967 permission, but the developer's case was that essentially, surely, the planning authority would have understood that the smaller planning permissions were being proposed within that context with, it said, an intention to make them work with the wider permission. The planning authority in the mid-2010s started to be concerned about where things were going. It sought my advice. I told them that they ought to rely on the Pilkington line of authority, even though that hadn't been done to date, and that provided a proper and lawful basis for them to tell the developer to stop carrying out any further works on the site in reliance on that old 1967 planning permission. And then the fireworks went off when that opinion was sent to the developer, and we ended up in the High Court again. The developer brought another High Court claim saying essentially, well, look, we've been here before the High Court in 1987. Court said once we can rely on the historical planning permission, surely the planning authority is bound by that judgment. No, said the High Court and the Court of Appeal. Those courts agreed with us, the planning authority, that matters had moved on since 1987 with all of that additional development in the northwestern part of the site. And the courts accepted that it was legitimate and proper for the park authority to rely on the Pilkington line of authority, which I'm coming on to, even though that hadn't been brought to the attention of the court in 1987. So in a nutshell, the courts below said, planning authority correct, the 1967 permission can't now be relied upon. So let's step back a minute, and just for some of you who might not be as familiar with the case law, let's just remind ourselves, what is this Pilkington case? What's it all about? And why was Pilkington so important in the reasoning of the court in the Hillside case? So I have deployed all of my GCSE in flip art over the next few slides to try to bring this alive for you in, I hope, a clear way. But what happened in Pilkington was this: you had a landowner who had built a house on a part of his wider land. I'm going to call that part of his land Site B. And you can see there, so the house was built in reliance on a planning permission on the part of the site that I'll call Site B. And there was also a part that I'll call Site A of that land. It was a condition on that planning permission that the house on Site B should be the only house on part of the wider land. All good so far. What then happened was that the owner, rather fortuitously, you might say, or unfortuitously as it turned out, the owner then found, having built this house on Site A, he found an earlier planning permission to build another house on the other part of the land, the Site A area. But the plan submitted with the previous application for that planning permission showed the rest of that land used as a small holding. So yes, house on Site A, but the rest of Site B, no development on it, being used as a small holding. So the question that arose in the Pilkington case, well, the developer thought that Christmas had come early. He thought, right, well, I can do both. I can have my house on Site B. I've got that already in the bag. I've now found this earlier permission. It deals with another part of the site, so surely I can build a house on that part of the site also. So the question before the court was, is that possible? Is that legally possible? And the court ruled, no, it wasn't possible, because the court said that the implementation of that later permission for Site B, so the owner's decision to build the house on Site B and rely on that planning permission, it had made it impossible to implement that earlier planning permission relating to Site A, because, as we recall, that earlier planning permission for Site A was predicated on Site B having no development on it at all. So having elected to carry out development on Site B, essentially the court said that it was physically impossible now to carry out the planning permission for the house on Site A in accordance with its terms, because the implementation of Site B had destroyed the small holding. And in Pilkington, the key passage of the judgment of Lord Wigley was this. It's the principle of physical impossibility. One looks first to see the full scope of that which has been done or can be done pursuant to the permission which has been implemented. One then looks at the development which was permitted in the second permission, now sought to be implemented, and one asks oneself whether it's possible to carry out the development proposed in that second permission, having regard to that which was done or authorised to be done under the permission which has been implemented. In summary, a principle of physical impossibility. Now, how did Pilkington play out in Hillside? Well, in Hillside, the developer tried to say that Pilkington was distinguishable on 3 grounds. The developer said, well, Pilkington is really based on the principle of having abandoned the right to develop the land. If you look at what the Hillside developer's done over the years, all the evidence shows that it hasn't really intended to abandon the old 1967 permission. Second key argument, main argument, was to say, well, in any event, the 1967 permission should be interpreted as what was called a severable planning permission, authorising separate clusters of housing within the site. So the fact that you might not be able to develop some of the clusters because of subsequent development doesn't mean that you can't go back to build some of the other clusters. That was called the Lucas argument, based on a judgment of that name. And there was a further argument saying that actually, when you look at these subsequent planning permissions, they are in substance variations of that 1967 permission. No, that's not really something we are used to dealing with in planning. The 1990 Act doesn't seem to provide for those, but the objective, fair interpretation of those subsequent planning permissions is that that is what they were. And so they had kept essentially the 1967 permission as varied alive. The appeal was unanimously dismissed. In summary for you, on the abandonment principle, the court said, well, Pilkington can't be explained on the basis of abandonment. Indeed, there's no principle of abandonment in planning law. The true basis of Pilkington was this principle of physical impossibility, and that is what we need to understand when we are looking at Pilkington. And that test of physical impossibility applied to the whole site covered by the implemented permission. You recall our Site A permission with the house and the small holding at the bottom. Doesn't matter if you might be able to build development on a particular part of the site. You've got to look at the whole site, and you've got to look at the planning permission and its entire terms. On the question of severability, the court said no. We don't like Lucas. The developer was wrong to rely on Lucas. Yes, Lucas had been decided on the basis that an old planning permission for a cul-de-sac of 28 houses should be interpreted as separately authorizing each of those 28 houses. But the Supreme Court decided in Hillside that Lucas was clearly wrongly decided. It couldn't see a basis for having interpreted the planning permission in that way. So the court rather went further than some of the courts below, who had been content just to express skepticism about Lucas. So this whole concept of a severable planning permission, Supreme Court didn't like at all. The Supreme Court did clarify that if you don't complete a development for which permission is granted, that doesn't mean that the development already carried out is unlawful. That was a helpful clarification because of arguments made about a case called Sage that you might have heard about at the House of Lords judgment. But the courts did say that, that being so, if there are no clear words in the planning permission to make it severable, and it's difficult to conceive of a local planning authority being ready and willing to want to make a planning permission severable, but if there aren't any clear words to that effect, then a planning permission can't be interpreted as authorizing further development if compliance with the permission has become physically impossible due to other development carried out. And the court simply said, if you look at the 1967 permission, you look at that master plan, the Hillside historical permission clearly was not a severable permission. It was intended to work as a single integrated whole. And the passage that perhaps has generated the most commentary in the in Hillside Supreme Court judgment is this passage in paragraph 72, where the court said this: it follows that carrying out under an independent planning permission on any part of the Abu Dhabi Balkan Hills site, development which departed in a material way from that scheme would make it physically impossible and hence unlawful to carry out any further development under the 1967 permission. Now, on the just to complete the Supreme Court's judgment on the variation point, very simply, the court said on the variation argument, you'll recall this argument of, well, the subsequent permissions should really be interpreted as variations which kept the 1967 permission alive. The court said no, the reasonable reader really wouldn't interpret those permissions in that way, because they were planning permissions granted only for particular parts of the site. They were not seeking to re-grant the entire planning permission again, subject to some modifications. So in a nutshell, everyone, all three of the main arguments of the developer were rejected by the Supreme Court. Now to the bit that you're probably most interested in this morning. What are the practical implications of this judgment in Hillside? There's been an awful lot of commentary in the planning press that it somehow sounds the death knell for what we know in the trade, we call in the trade, drop-in applications. Many commentators saying, well, surely this judgment is indicating that there must be less scope for flexibility in future when making planning applications for complex schemes. But hang on a minute, what do we really mean when we talk about a drop-in application? A drop-in application, we know, usually means, it can take different forms, but it usually means an outline planning permission for a large multi-phase development. And you need to make changes which can't be accommodated by a normal Section 73 application. And then you make a drop-in application for a different form of development for a particular phase. And then in the usual way, you tidy it up with a Section 73 application to amend conditions on the main permission so that it's not inconsistent with carrying out works under the drop-in permission. There are variations on the theme, but that's what a drop-in application is. Can I just underline to you all this morning, the Hillside case was not about drop-in applications. The 1967 permission wasn't an outline planning permission. It was a full planning permission granted subject to a detailed master plan. The 1967 permission wasn't subject to a phasing condition. There wasn't a single Section 73 permission ever granted in the history of the case. And Hillside simply didn't concern the modern practice of using drop-in permissions in the context of an outline planning permission for a large multi-use development. And at no point did the courts below, or indeed the Supreme Court, use or even refer to the concept of a drop-in permission. So my main message to you this morning is I think that this argument or some of the commentary to the effect that Hillside sounds the death knell, for drop-ins is greatly overplayed in my view. We must remember that Hillside involved some highly unusual facts where you had a developer seeking to rely on a very old, 55-year-old indeed, detailed planning permission that had been overtaken by subsequent detailed planning permissions. We had that added complication of the 1987 judgment of the High Court, which hadn't mentioned Pilkington, and that had led the developer probably to have misplaced confidence in its case. And we also unusually had a site where development had progressed at a glacial pace. So whilst it's likely, I think, that we'll see further case law on the implications of Hillside for the use of drop-in applications within multi-phase schemes, it's not, to my mind, an inevitable that will happen. Whether a drop-in application raises a Hillside issue, and these are the practical questions that you need to ask yourself. Two, I think, in the main, if you're dealing with cases with a potential Hillside issue, is the drop-in application for a genuinely independent planning permission, or is it for a permission that is codependent on another permission? Because if it's codependent on another permission with a drop-in and any related Section 73 application for the main outline consent, if they work as a whole to achieve a coherent overall scheme, I see Hillside as clearly distinguishable. And perhaps more fundamentally, ask yourself, does the drop-in application result in a material departure from the main permission that the developer still wants to rely upon? That issue of materiality will be a question of planning judgment. If the departing development can be readily reconciled and connected with the remainder of the development authorised by that main permission, seems to me very unlikely that a planning authority would consider it expedient to prevent ongoing reliance on that main permission. The problem in Hillside was the extent of the departures was really so significant. So in conclusion, 2 points that I would invite you to take away. Hillside, in my view, will pose very limited risk when drop-in planning permissions are implemented at the end of the development process, by when all the development sought to be carried out and the main permission has already been carried out. Where I see the greatest risk, perhaps, with Hillside is when drop-in permissions are implemented at the beginning or middle of the construction process, before the developer needs to go back and rely again on the main permission. If you can't amend the construction schedule to push the implementation of any drop-in permission to the end, then relying on a drop-in planning permission is perhaps unlikely to be prudent, although it will depend on the facts, the extent of departure. That's where legal advice will be key. And final point is that the significance of Hillside might well be short-lived if the proposal to insert a new provision in the Town and Country Planning Act 1990 goes ahead. There is provision being made in the Levelling Up and Regeneration Bill for a new procedure to seek planning permission for development, the effect of which will not be substantially different from an existing permission. If that's enacted, and it seems very likely to be enacted, that would give, of course, developers a new route to achieve moderate variations in planning permission. and that should be welcome to everyone, by everyone, because it will provide the legal certainty that is inevitably sometimes lacking when we're relying on the drop-in method. So the significance of Hillside in the long term could be somewhat reduced if that goes, that change in the law goes ahead. I hope that's helpful. Thank you all for listening.
Hello, everyone. Thanks very much, Gwion. I'm now going to talk to you about planning, about practice and procedure, including Aarhus Costa, which is really, it's just an update on case law from the last year on a couple of issues. So yeah, I'll just take them in turn. The first then is we have a new piece of legislation, the Judicial Review and Courts Act 2022. Introduce a few changes, and of most relevance to planning cases is probably the introduction of new remedies, and in particular the introduction of suspended quashing orders under Section 1 of the new Act. Now, I don't anticipate that these will be widely used, but they could have implications for planning cases where, for example, a local planning authority asks for a quashing order to be suspended to give it time to correct some defects in a permission. Which could end up with a bit of a Pyrrhic victory for a successful claimant. And a couple of examples where that might have worked in some circumstances is a case called Nicholson-Allerdale, which some of you might be familiar with from, it's quite an old case now, but in that case, there was a complaint that a condition attached to a planning permission, which was about noise mitigation, had just been wrongly stated. It had used the wrong, it used average noise readings, I think, instead of maximum noise readings. And Mr. Justice Holgate found that was correct, found the condition was unlawful, but instead of quashing the permission, what he did was he handed down his draft judgment and then adjourned to give the developer and the local planning authority the opportunity to change that condition by way of a Section 96A application with a sort of a minor a non-material amendment to the condition. And then he gave his final judgment and decided he didn't need to quash the permission because the issue had been remedied. It's possible that he could have done that in a different way, using a suspended quashing order by making the quashing order, giving the local planning for a period of time to make the amendment. They may not have been able to do that by Section 96A because obviously the planning permission would be quashed, but they can nevertheless make the amendment another way, perhaps by Section 73, and then that would have meant that the permission could have been rescued or could have been kept up without it being quashed, without any sort of hiatus which would follow from a quashing order. And another example possibly is the case of Howe and the Secretary of State of the Home Department. That was a judicial review brought against the Secretary of State, granting herself a special development order for the use of Napier Barracks to house asylum seekers. It was brought to a number of grounds. It failed on all but one, which was a public sector equality duty ground, and it was found that Mrs. Justice Leven found that the Secretary of State needed to go away effectively and do some more work, more assessment under the public sector equality duty. Possible that suspended quashing order could have been used in that case to give the Home Secretary more time to do that work, so that she could then come back with the sort of lawful SDO without the need for any sort of hiatus in between the quashing order and her coming back. So we may see those used in some planning cases. I'm not sure, but it's worth being aware that that's a power which is open to people to use. And then there's been a few cases on issues of standing, service, time, and cost, which I'll go through. And we've got the Good Law Project to thank for quite a few of these. Particularly in relation to standing. So there are two cases which involve the Good Law Project and standing, which I want to talk to you about. First is the Good Law Project and the Prime Minister earlier this year. That was a judicial review of decisions to appoint individuals to senior positions critical to COVID response, so including the head of the vaccine task force. It was alleged that was unlawful in a number of respects, and including that there'd been a failure to follow the public sector equality duty in ensuring that the application process was open to people from all different backgrounds. Now, that claim was brought jointly by the Good Law Project and the Runnymede Trust, but the Secretary of State or the Prime Minister took point on the standing of the Good Law Project, and the court effectively agreed. It found that obviously found that no person or other group has standing to bring judicial review proceedings in all cases. Now, that was a reference to the Good Law Project's Articles of Association, which were very broadly worded and effectively did seem to purport to grant itself the right or ability to bring judicial review proceedings in any case. The court found obviously that can't be correct. No group or individual will have standing in every single possible case. And indeed, in this case, it found that the Good Law Project didn't have standing to bring certain grounds, and certainly didn't have standing to bring the public sector equality duty ground. In this case, it wasn't sufficiently closely connected or affected by the decision to have standing to bring that ground. But it did find that the Runnymede Trust had the standing to bring that ground because it was an organisation which existed to promote racial equality. And that Good Law Project case has now been sort of encapsulated in an updated paragraph in the Admin Court Guide, which you can see it there. It says an association or non-governmental organisation claiming standing will normally have to demonstrate a genuine involvement in a specific subject area. The court will not necessarily accept that a corporate entity with very widely drawn objects will have standing to pursue claims in every case whose subject matter falls within those objects. So I think the point to take from that really is that it's unlikely that this will be an issue for claims involving individuals, but where you have large groups and charities seeking to bring claims, it's possible that the courts will take a slightly less lenient approach to standing than they previously were. And if you're acting for a defendant, it's perhaps more worth asking yourself the question, does the claimant have standing, than it was before. In most cases, it's likely that the claimant will have standing. Courts still take a broad approach to it, particularly in environmental claims. But I think these cases show it's more worth asking that question. And then the second Good Law Project claim against the Secretary of State for Health and Social Care, again, the Good Law Project was found not to have standing in this case because, and this was a procurement case about the awarding of contracts for lateral flow tests and things like that. The court gave a bit more sort of detail in terms of how to approach the issue of standing. They said it's a multifaceted question, and it will the court will have to have regard to all of those factors there. So in terms of merit, that will be how meritorious is the claim overall. Clearly, that's a factor in whether the court will allow a claim to proceed with a person who might not otherwise have standing, but it's not always going to be decisive. Context. So what's the context of the claim? What are the regulations under which you're claiming, etc.? In that case, it was a procurement claim, and the court found you'd usually expect those sorts of claims to be brought by the economic operators whose interests were the subject of the regulation, so people who would have been actually financially disadvantaged by an unlawful awarding of a contract, as opposed to someone like the Good Law Project who had no economic interest in the claim. Again, not decisive, but some weight would be given to that. The effect on the claimant, so has the claimant actually been adversely affected by any alleged unlawfulness any more than any other member of the public? So do they have any particular interest in it? Gravity, so how serious effectively is the breach? That will be relevant. The existence of other possible claimants, so are there other people who could theoretically bring a claim but are unlikely to do so? That might be relevant, and obviously that was relevant in the previous case because you had the Runnymede Trust who was there bringing the claim, and it was more appropriate that they should have standing. And then finally, the claimant's position. So what is the position of the claimant in respect of the actual case? And that requires some consideration of all of the circumstances of the case and any particular sort of insights that the claimant might have had. So some more guidance really in terms of how to assess standing. Then in terms of timing, this was a case, a permission decision, so only a permission decision from late last year that James and I were involved with, Save Britain's Heritage and City of London to do a large redevelopment on Fleet Street. The issue there was, it turned on timing. The claimant had issued the claim late effectively, but argued that it was in time because the time for bringing a judicial review of grant of planning permission, they said, ran from the date on which they'd been told that the permission had been granted, not on the date on which the permission was granted. The court disagreed. It found, I think conventionally, looking at Burkett and other cases, that the time for bringing judicial review runs from the date the permission is issued, not the date it was communicated, if it was communicated later, for example. But that might be different for an EIA ground of challenge, following a line of cases based on uniplex, where it is suggested that the time might run from the date on which you found out, or that the unlawful act was communicated to you. But ordinarily, it will be the date on which the permission was issued. And what the developer was looking to, so what the claimant was looking to argue in that case was that because the permission was for EIA development, the uniplex principle should prevail, even though none of their grounds were based on any breach of the EIA regulations. And the court disagreed with that. So there's no difference where the permission is for EIA development. The only thing that might make a difference is if you are bringing an EIA ground. And then a few cases on service. Another Good Law Project case, you get the impression that the Good Law Project's been sort of testing the court's willingness to entertain certain cases and sort of testing the limits, and that's led to some of these judgments on standing, and also this one on timing, which some might regard as quite a sort of rigorous application of the civil procedure rules. This is a separate challenge to the Secretary of State for Health and Social Care. And effectively, on the facts, what happened was that the Good Law Project was told what email address to file to serve the claim form on, the government email address, but it used the wrong one. So it did a couple of things. It did serve an unsealed claim form on the right email address, but it served the sealed claim form on the wrong email address. It still reached the relevant people, even within the time limit, but that wasn't effective service. It wasn't valid service. So the point was taken, and the court required the Good Law Project to make an application to extend the time for serving its claim. And the court reviewed the relevant rules that apply to such applications. Good Law Project, the Secretary of State sought to rely on Rule 7.6 of the Civil Procedure Rules. The court found that that didn't apply for judicial review claims, that applied just to Part 7 claims and not to judicial review claims. But nevertheless, it found that the principles are relevant. So the proper rule to apply for judicial review claims is Rule 3.1, part of the court's general case management powers to extend deadlines. But when you're looking at that in the context of a judicial review, and presumably any other claim where you're looking at late service, the principles that are contained in Rule 7.6 will be relevant. And those effectively are, well, you've got to make an application an application to extend time within time, if possible. And if it's not possible, then the court's going to consider how promptly you made your application and what was important in this case, and whether all reasonable steps were taken to effect valid service within the proper time limit. And it found in the case of the Good Law Project that all reasonable steps had not been taken because they knew the right email address to send. It was just effectively an error. Was the reason why they didn't serve it properly. And even though it was quite a technical point, that was sufficient for the court, and they refused to extend time. And then a further point has popped up from that, which I've just seen taken a couple of times by the court, which is about this difference between actual and deemed service. So there's a line in the Good Law Project there that explains that the service means actual service, not deemed service. Now that is obviously correct, and deemed service is a sort of fictional date that's created by operation of the civil procedure rules, and principally that's created so as to give the defendant certainty about what time limit he has to respond to a claim in. And actual service is the relevant date, but importantly, actual service doesn't mean the date on which the defendant received the claim form. It means the date on which your claimant completed the relevant step in Rule 7.5, and there's obviously a list of steps like posting the claim or whatever it is in there. That's the date on which you carried out actual service, and that's the date that is relevant for the purposes of serving a claim form. And Paxton Jones and Chichester Harbour is authority for that point. And then another just warning really about service in this tax return case, particularly service by email. In that case, the defendant had given 2 emails for service, and that was a problem because the relevant rules, the relevant practice direction about service by email requires the defendant to state an email address by which they're willing to accept service. because it was found that because the defendant had specified 2 email addresses, it wasn't possible for the claimant to elect which email address to serve it on. And actually, they couldn't validly serve it by email in those circumstances. The only way they could validly serve was by another means, or they could have gone back to the defendant and clarified which was the email address for service. So just beware when you're trying to serve claims. Make sure you serve them in time, or take every possible step to do so and apply in time for extensions. And where you've got various email addresses, make sure you clarify which is the email address which they're willing to accept service to. And then I think finally on Aarhus, there's a judgment called Lewis and the Welsh ministers just raised a couple of interesting points about Aarhus. First of all, the definition of an Aarhus claim requires attention to be focused on the nature of the claim and not its subject matter. So just because the subject matter of a claim might be environmental in nature, that doesn't mean the claim will necessarily be an Aarhus claim. It depends on what is actually being pleaded, what error is being asserted. So in that case, a pure public law challenge, i.e. a failure to have regard to a material consideration, might not without more be enough to bring a claim within the Aarhus Convention. But having said that, if one of your grounds is a environmental and sort of Aarhus ground, then that would be enough to bring the whole claim within the relevant cost caps, provided that claim is not brought in good faith and not just a sort of a deliberate add-on to bring yourself within the cost caps. But it's important to note of that decision that was a decision. The decision on the challenge was not a decision to grant was not a planning decision itself, but a decision to adopt a business case. And I do wonder whether the court would take a different approach to an application for judicial review, a decision to grant planning permission or a Section 288 claim, where it's quite plain that there are environmental matters at stake in the challenge, but worth having a look at anyway, Lewis, particularly if you're a defendant or indeed a claimant. And then a couple of other points that flow from that, which is where the claimant brings the claim as an individual and on behalf of an unincorporated association, as happened in that case, the court won't automatically assume that the £10,000 cap applies. In that case, it found that the £5,000 cap was appropriate. And then in terms of completing a statement of financial resources, the court found it was fine to estimate the likely amount of money you might receive by crowdfunding, and that's fine so long as it's a genuine estimate. And it doesn't matter that, in fact, by the relevant time, by the conclusion of the claim, for example, it doesn't matter that amount had been exceeded. As long as it's a genuine estimate, that's all you need to do, and that's what the court will look at. And that's it in terms of practice and procedure. And so I'm now going to hand over to James and to Sasha.
Hi. Sasha and I are going to try and cover over the next 25 minutes or half an hour or so the Levelling Up and Regeneration Bill and other mooted planning reforms, not in terms of what they are, but in terms of the likely issues for future High Court litigation. In choosing this topic, which I think we chose back in March 2022, little did we know how much would change. Obviously, we've had about 57 governments since then, and it does bring to mind the quotation, which I think is often attributed to Niels Bohr, that prediction is difficult, especially if it's about the future. Now, I have to say that if we move to the next slide, in terms of what we're going to cover, obviously some of these reforms have fallen by the wayside into the scrap bin of history in recent weeks. But the LERB seemed pretty certain in terms of where it was heading. But of course, now, as we know, even LERB itself is in some difficulties from backbench MPs seeking to hold the government to ransom. And I'll come to some of those maybe towards the end in terms of what any implications of that might be. There's also the famous quote, isn't there, that politics is the art of the possible. And I do fear that in this country, we're reaching a stage where any planning reform is beyond what government can actually achieve. So if we move to the next slide, we'll talk about, and move on one more, we'll talk about some of the key aspects of LERB, assuming it does actually make it onto the statute book in due course. So the first change I want to focus on is to the role of the development plan and national policy in decision making. If the bill becomes law, we will be saying goodbye in England, but not in Wales, to our old friend, Section 38(6) of the Planning Compulsory Purchase Act 2004. As you all know, that provides that any determination of a planning application should be made in accordance with the development plan unless material considerations indicate otherwise. That's been with us since 2004, but it was itself a reenactment of a provision that's been with us since 1991 in the shape of section 54A. So if we move to the next slide, how section 38.6 works, as you'll know, is now very well established, as is its relationship, as is the relationship between national policy and the development plan under that provision. So there are a number of key cases that everybody knows, like Edinburgh, which set out how the statutory provision works. We also know from many, many cases, and BW trading in 2016 is just one of those, that planning policy in terms of national planning policy, unlike development plan policies, does not have the force of statute, does not have the same statutory status as the development plan. And there are many, many other cases like Hopkins Homes and Gladman, which have looked at that issue. Now, if we move on one slide, just in terms of Hopkins, there's a very good summary from Lord Carnworth, again explaining the difference under our current provision between the development plan and national policy, which is a mere material consideration. There's also an interesting account in paragraph 8 of the history of this provision about determining in accordance with the plan unless other material considerations indicate otherwise, and the whole provision of other material considerations, which has its origin in the 1947 Act. And it's recorded by Lord Carnworth that the aim of the provisions that were inserted in section 54A back in 1991 was to enhance the status of the development plan, to give it that statutory presumption. So moving on, what's proposed? Well, clause 83 is going to insert the following into the 2004 Act, and there are really three aspects to this. First of all, one now must, under the statute, have regard to both the development plan and any national development management policies. So a statutory status to national planning policy for the first time, if the policy is designated as a national development management policy. Secondly, the determination of a planning application will now have to be made in accordance with the development plan and the national development management policies. So both development plan and national policy, unless material considerations strongly indicate otherwise. So a change to that language too. And then thirdly, if there's conflict between the development plan and national development management policies, then the national policy prevails. So moving on, also one has in clause 84 the fact that for a national policy to be a national development management policy, what's required? What's required is merely that the Secretary of State so designate it, and does so having undertaken such consultation as the Secretary of State thinks appropriate. So moving on, what are the judicial review, statutory review issues that arise from this change? Well, there are potentially quite a few. As I've said, all the principles about how section 38.6 works are really well established. They're all going to be up for grabs again. So excellent news for lawyers, perhaps not so excellent news for everyone else. The bill is radical in two regards. One is it's strengthening, it can be said, the importance of the development plan, because applications must now be determined in accordance with the development plan unless material considerations strongly indicate otherwise. So that's strengthening the power of the development plan. But at the same time, it's also weakening the power of the statutory development plan, because national management, national policy in the form of national development management policies will have the same status, first of all, under the relevant section, but actually will trump development plan policies where there's a conflict. And in terms of other issues, what does strongly indicate otherwise mean? How is that different from the old indicate otherwise? How is it different from the MPPF paragraph 11 test of significantly and demonstrably outweigh? So again, plenty there for lawyers going forward. Next slide, please. And then, given that now one must comply with the development plan unless material considerations strongly indicate otherwise, it becomes even more important to know whether your proposal is in fact in conflict with the development plan. And we'll have to look again, I think, at cases like Cummins, which holds, of course, that just because you breach one policy in a development plan doesn't mean you're not in accordance with the development plan, because you may be in accordance with the plan overall. That's going to become another key issue again. It's going to need to be revisited, I suspect. I think there may also be legal challenges to the designation of national development management policies. That seems to me a possibility that's going to arise under this new bill. And also, I question now whether the reasoning of the court in the Friends of the Earth case as to why the MPPF, and indeed one might also say the PPG, don't require SEA is now destroyed by this new bill, such that if SEA remains, there may have to be SEA every time the MPPF or the PPG is changed. That's something that will have to be explored. I'm now going to hand over to Sasha for the next run of issues.
Thank you, James. So I wanted to look at environment outcome reports. These are obviously intriguing. They're potentially exciting and potentially very good for the environment. But obviously under the regulations, which haven't yet been laid, it's difficult to know exactly what they will look like. For example, property rights and infrastructure may exist when it's discovered that the proposed mitigation and the mitigation that was supposed to be taking place isn't effective. The MMO actually has already a power to take further action if environmental harm is being caused following the grant of a marine consent, and it's very rarely used. Currently, there are, I think, two key points to take from where we are on EORs. The first is that whatever the actual specified environmental outcomes are, which will have to be laid, that is to be subject in the regulations to public consultation and the affirmative parliamentary procedure. So we can expect to see development around that and people looking at what it is they're saying. The second is that the underlying regulations will then have to set how it will be monitored and how action may be taken to increase or potentially decrease what is to be done, and what will happen if it's not effective. And none of that is clear yet. The key question, I think, that we'll be looking out for in clause 121 will be whether a consent can be removed if the impact cannot be mitigated effectively. There is an important difference in the proposed consultation between the first setting of regulations for specified environmental outcomes and the second in relation to how it's going to be monitored in order to enable the concept of dynamic mitigation. It is proposed that there will be safeguards, and I've set those out there. The intention is that the safeguards will be such that environmental protection will not be less than that provided by environmental law at the time the Act is passed. One can see the potential on an individual scheme for challenges there. Also, they are not to be inconsistent with the implementation of international obligations of the United Kingdom. Again, one can see the potential for challenge there. If on an individual scheme, it can be shown that it is in some way inconsistent. There is again the commitment to consultation, but again, not clearly specified yet. Consultation has historically been a good ground for challenge. The precise way in which the proposed EOR regulations will relate to existing environmental assessment legislation and the habitats regulation is also not clear. The new EOR regulations may amend, repeal or revoke existing EIA legislation, but the provisions aren't referring there to the habitats regulation. So again, there may be scope for challenge if you have conflicting regimes. This slide is simply indicating the large amount of information that is not currently known yet as to what the EOR's regulations laid under them will look like. There are other important elements of the new proposed structure. A number of these are likely to be similar to what we have in EIA currently, for example, Category 1, Category 2. Similarly, that there is likely to be circumstances in which the Secretary of State may direct that no EOR is required. Interestingly to note here is that there isn't a change being proposed, clause 125, essentially in relation to enforcement. The intention is that breach of these regulations will not be an imprisonable offence. From the perspective of environmental enforcement, that's obviously giving in principle a lower standard in that criminal context than perhaps might have been considered given the growing importance being given to protection of the environment, but it is of course consistent with the ordinary planning regime. This is summarising potential areas for potential future litigation, the new concept of outcomes, the impacts of dynamic mitigation, the rationality and subject to the regulations, effectiveness of the safeguards on individual schemes, the application of international law. The Aarhus Convention is now well understood. There are hundreds of cases that have considered Aarhus, and whilst many of those cases, the impacts related to Aarhus have been translated through EIA, people use them and the courts are familiar with them. In relation to ESPU, there's been 8 cases listed on Westlaw, and the last consideration in the UK courts was 2014. Many people probably in this session won't even have heard of the ESPU convention. It is the convention that looks at environmental impact assessment in a transboundary context. All of this together means that the principles established to date in EIA or SEA case law will likely need to be re-established. There are many potential points, but they will require the regulations, and it's not clear currently what the appeal route would be. Somewhat amusingly, the explanatory notes state that there will be familiarisation costs for local authorities in having to understand all these changes that are proposed, and one might say to many others as well. But it is considered that the new system of environmental outcomes reportings, those costs will all apparently be balanced by efficiency savings. I'm sure everyone will be pleased and perhaps sceptical to know that that is the government's view.
Thanks, Sasha. I'm just going to deal with heritage assets briefly. I think we're all well familiar with section 66 of the Planning Listed Building and Conservation Area Act, and the duty to have special regard to both the desirability of preserving the building, but also its setting, and then also the special regard that must be had to the desirability of preserving and enhancing the character and appearance of a conservation area. These provisions, especially 66, have been the subject of really huge amount of litigation in recent years, including on the extent and the nature of the duty to have special regard, and also the relationship of these provisions to national and local policy. Westlaw tells me there's 105 higher court cases since March 2012 on section 66 and 74 on section 72. But there isn't currently any similar statutory provision for other heritage assets, such as ancient scheduled monuments, registered parks or gardens, World Heritage Sites, and sites protected under the Recs Act. And that's all going to change in clause 92. Now there will be a duty to have special regard to the desirability of preserving and enhancing a number of historic assets, including all the ones I've just mentioned, so heritage sites, scheduled monuments, parks and gardens, etc. So I think there'll be a tsunami of litigation alleging breaches of these new statutory duties in respect of their assets and their significance. As there has been in relation to listed buildings and conservation areas, one oddity that occurs to me is that when this bill comes into force, if it does, all heritage assets, apart from conservation areas, will have specific statutory protection for their setting, but conservation areas won't. I don't know why. So I'm going to hand over to Sasha to look at the next topic, which is infrastructure levy.
Thanks, James. So the infrastructure levy, the first slide I've set out there is what the explanatory notes to the bill tell us as to what is the intent about the infrastructure levy. And the intent is that there should be a new infrastructure levy tailored to local circumstances, that it should be set at levels that exceed or maintain previous levels in relation to levels of affordable housing, and there is to be a new duty to do it. The problem in this noble aim is that it currently lacks any real detail as to what it's going to look like. The intention had been, as it was discussed, to be based on the gross development value, not floor space, but clearly there's likely to be both evidential and legal uncertainty in establishing those, which will likely lead to litigation. The intention is that it will be based on locally set charging schedules. The detailed design of those is highly likely to be challenging. Again, that's likely to lead to litigation. The regulations will give provision for evidence, including evidence that is to be taken to be not available, how evidence is and how evidence is not to be used. And it will provide for examination of the schedules. Both of these examinations will, in the examination itself, it leads to litigation in the inquiries, and given the volumes and the amounts of money that may be at stake, will also be likely to lead to litigation. The application of the charging schedules, when they are actually established, will also be used in appeals, and they will also be likely to lead to litigation. To give some idea of the complexity in translation to the setting of schedules, one can see in this slide here how you even set viability has not yet been determined to be laid down in the regulations as to how it is that local authorities are supposed to set it, and then how they are supposed to translate it to individual schemes. It's not yet clear whether the regulations will provide how those levels of affordable housing is to be provided and how the level of funding is to be measured. It's not yet clear how one is supposed to appraise actual or potential economic effects of the imposition of the infrastructure levy, and similarly matters relating to the actual or potential effects, including increases in the value of land. And then finally, not even simply as to the provision of infrastructure, it can also be any other matter that may affect the value of land, and regard may also be had to the costs of anything other than infrastructure. And finally, for those of you who may have thought that the purpose was in fact to limit it to GDV, actually the underlying regulations may permit it instead to be done by reference to floor space, numbers, intended uses of units within buildings, allocation of space within buildings or units, to values or expected values, or in any other way. Next slide, please. It's also not even clear yet what is intended to be included in the definition of infrastructure. There is in some sections a definition of what is to be inside the meaning of infrastructure. However, that is then subject to various other subsections. And critically, for example, 2040 makes it clear that that can also include anything else that is concerned with addressing demands that development places on an area. So currently, as it's moving forward, it may well be wider than infrastructure anyway. There's also no certainty yet as to how appeals will work. I'm sure everyone can read what is being set out there. It's obviously not decided yet. But what one can see is it's not yet decided even in terms of the grounds upon which an appeal may be made. We see from subclause 3 that the regulations will provide for a right of appeal on a question of fact in relation to the application of methods for calculating IL, including any questions in relation to valuation. So we know that it will be a merits-based tribunal, not, for example, a judicial review tribunal, but all the other factors are currently unknown. It may be speculated where it refers to other person that there is consideration obviously being given to sending it to the inspectorate, but the reference suggests that consideration may also be given to a court or tribunal. And if I hand over back to James.
So just briefly on plans and plan making. Under the bill, Schedule 7 makes provision for joint spatial development strategies, local plans, mineral plans and waste plans, and supplementary plans to replace SPDs. There is no right to be heard, specifically under the bill. It actually excludes the right to be heard in respect of joint spatial strategies. For supplementary plans, the purposes of the examination are very limited, and there's a presumption that the examination of such plans will be in writing only, albeit if a decision is made to hold a hearing, then there is a right to be heard. So the right to be heard remains, but only for local plans, waste plans and mineral plans, not for joint spatial strategies, and generally not for the supplementary plans. In addition, for local plans, there is now an enforced timetable which will be given effect to by regulations, so that there's an expectation that plans are produced within 30 months. Now, as you know, that is a hugely ambitious target given the current delivery on local plans. What does this mean for legal challenges? Well, you've got reduced levels of participation and the rights to be heard, fewer examination hearings, tight timetables for the adoption of development plans. That seems to me to be a classic recipe for more legal errors and more legal challenges. One other thing just to note, the bill also prevents a local planning authority withdrawing a plan once it's been submitted for examination, unless the examiner or Secretary of State so recommends. So we may be in a world in the future where court challenges will be made by local authorities to the refusal of the examiner and or Secretary of State to allow them to withdraw their own plan. I was just going to briefly touch on some other changes in the bill that could lead to further public law litigation. So you'll see they're changing the time limits for enforcement so that it's 10 years for everything. Whenever you change the time limits for enforcement, that always gives rise to nightmarish transitional issues, which occupy the courts for years after they change. So thank you for that, government. Secondly, we've got new provisions on neighbourhood plans and what they can and can't provide for. I think that's only going to fuel further challenges around neighbourhood plans. There's obviously the requirement for design codes. Could there be legal challenges to the adoption of design codes? I certainly think that's a possibility. There are also various CPO reforms, including adding regeneration to the purposes, a greater discretion on the appropriate procedure for objections at CPO, i.e. again, reducing the right to be heard potentially, and also allowing for the first time ever CPOs to be conditionally confirmed. Again, all of those things could and are very likely to, in my view, lead to further legal challenges. And then, as I mentioned at the beginning, the LERB is potentially in trouble because of a series of backbench amendments which are holding the bill up. One is to prohibit national housing targets and the 5-year land supply. I'll avoid comment on that one. The second is a good character test for the grant of planning permission. Now, Sasha and I don't necessarily agree about this one, but I think this is absolutely bonkers, not least of all because planning permission runs with the land. I just can't see how you can have a good character test for planning permission, and I can't really see what the point of it is. And then C, a community right of appeal, i.e. the old idea of a third-party right of appeal where a developer's granted planning permission. Again, wonderful reform for lawyers, that, but probably not for anyone else, and certainly not for anyone who wants to actually get on and build anything. Sasha.
Thank you, James. And just before we talk about the retained EU law revocation and reform bill very briefly, the reason why I do see merit in a good character test for the grant of planning permissions is that there are other areas of environmental law where similar obligations have been effective in driving standards. And the key one is around how the waste sites are operated and the programme of enforcement and monitoring that the Environment Agency runs, which do seek for operators and in compliance to ensure standards. And there are also suggestions in relation to fire safety, how these responsibilities can ensure that they are being delivered for lifetimes of the buildings that are being built. Turning then to the retained EU law revocation and reform bill, I mean, it's worthy of a brief note in this presentation. It's a somewhat headline grabbing that the government has found an extra 1,400 laws to scrap under the latest Brexit bill. Next, the key points, however, that are coming out of this for the perspective of environmental and planning cases, it isn't so much the end of the supremacy of EU law, because we're all aware that this is essentially what Brexit has meant, but what that is going to mean as it's being delivered into the UK courts systems. And the key points there is so much of our EIA and SEA case law is derived from retained EU case law, and the retained EU law bill is expressly making clear that these are no longer to be considered directly part of the UK law. They are to be appraised and assessed, and that a higher court may depart from this if it considers it's right to do so, having regard to, amongst other things, the extent to which retained domestic law has been determined or influenced by EU case law from which the court would otherwise depart. It's also relevant for lower courts or tribunals in that those may make references if they consider they're bound by the retained case law, and that law officers may similarly make references and must be given notice of proceedings if in a higher court any argument is being made in relation to the departure from retained case law.
So I was going to just come back briefly at the end and talk about the ill-fated and not very long trust reforms. Obviously, the investment zones we've learned very recently are now completely scrapped. People having spent a considerable amount of time and money making bids on those. Fracking, having been unbanned, has been banned again. And there is still, unfortunately, one of the trust reforms which seems to be retaining traction, which is banning solar on farmland or high quality farmland. So we can see plenty of measures there by the government to reduce our domestic energy supply, which obviously sounds like a very sound policy in the current geopolitical situation. But most of these trust reforms are dead, unfortunately. Not all of them are. Thank you.
Well, thanks very much, everyone, for those really interesting talks. We've got through a lot of material there, and we also have a lot of questions. We don't have a huge amount of time left, but I will try and deal with as many questions as we can. So going right back to the top, Gwion, question on the Hillside issue and the issue of severability that you mentioned. How do you think it would be possible to demonstrate that elements of a scheme are severable? Because it's difficult to see how a local planning authority would welcome such severability. How do you think that's going to work?
The short answer, Jenny, is I don't think it is going to work, because I don't think there'll be any appetite at all on the part of local planning authorities to do that. I think the Supreme Court in Hillside and indeed the Court of Appeal below were entertaining the theory, that if a planning permission were granted, where you had the description of development stating clearly on its face that it was intended to be interpreted in that way, possibly that could be done by condition also, but I would imagine that the best place to do it would be in the description of development. Then conceivably, in theory, a planning permission, the court said, could have that effect. But the practical question is why? Why would a local authority want to do that? And why would they want to create a risk or possibility of effectively a pick and mix approach to different planning permissions? Because if you had, let's say, two severable planning permissions side by side, that is what that would effectively allow or risk allowing. So I can't see it happening, I'm afraid, even though it might be technically possible, say the courts.
Yeah, because I think the effect of the Supreme Court judgment is it has to be very clear. It's not like you can sort of interpret it by the fact that there are different phases or something like that. It has to, they're envisaging it being very clear on the face of the permission. And at the time of making that granting that permission, it's difficult to see why an LPA would want to do that, isn't it?
Indeed. And the courts did also say that it is unlikely to be the correct interpretation of a modern planning permission that is subject to phases. So I think it's a comment of more academic interest, I think, rather than one of real practical significance.
Okay, yeah. Another quick question on your talk, Gwion. Abandonment. We're familiar with that principle in certain circumstances in planning, but as you said in your talk, the Supreme Court cast doubt on that applying at all. What's your view, and does it have any ramifications for things like whether a use has been abandoned?
This is a really excellent question, and let me clarify it if I can. One consequence, everyone, of Section 75, subsection 1 of the Town and Country Planning Act, which states that planning permission inures, that legal term, for the benefit of land, is that there can't be any doctrine of abandonment in relation to planning permissions themselves. And that was confirmed by the House of Lords in a case called Pioneer Aggregates in the mid-80s, and the Supreme Court reaffirmed that in Hillside. Now, this question, this will be of interest, I'm sure, to those of you on the call who work in enforcement in particular, that the question of whether a lawful use right obtained other than by planning permission, the question of whether such a lawful use right has been abandoned, it's important to underline that is a separate and different question and involves a whole body of case law that wasn't considered by the Supreme Court in Hillside. And as I read it, the Supreme Court wasn't seeking to offer a view on that body of law, even though on the face of it, it appears that it was making a pretty general statement about no scope for abandonment at all, in planning law generally. In my view, it is still clear that the right, other than by virtue of a planning permission, to continue to use land for a particular use, that is still that right capable of being abandoned. So the entire line of authority that comprises cases like Hartley and the Minister of Housing, Ratcliffe and the Secretary of State, White and the Secretary of State, all those authorities, in my view, remain good law after Hillside. So I hope that that is reassuring.
Anyone else have any comments on abandonment, how that might still apply? Yeah, I was thinking of the Hughes case. It's those 4 tests, isn't it? And I wouldn't have thought that the Supreme Court would necessarily have affected that. Okay, one other one for you, Gwion, and this is a question about a master plan. So it's if you had, if in Hillside, instead of being a full planning permission, it had been an outline planning permission, but with a master plan setting out plots and layouts. Do you think the outcome would still have been the same if subsequent buildings had conflicted with that master plan, if subsequent permissions have conflicted with the master plan rather than with a full permission?
So the answer is yes, I think. So let's just work through the facts in that scenario. The facts would be that you'd have an outline planning permission, but with then, as I understand it, a detailed layout approved as part of that master plan, but no other details approved, although I think it probably would have been the case that the layout couldn't have been approved in detail without also approving the access in detail. But the scenario I think that's put to me is, well, you then still have separate planning permissions granted for parts of the site that were inconsistent with that approved layout. And the developer would then still be trying to fall back on the originally approved layout. It seems to me that the same principle of physical impossibility would have applied in that scenario. And of course, by that stage also, there'd be no question of being able to seek approval for an amended or different layout under the outline planning permission, given the passage of time. So as I understand the scenario that's put to me, and I hope I've understood it correctly, I think the outcome would, yes, have been the same.
Yeah, I mean, would it be like if you had parameters plans effectively, like under an EIA type application, outline application, where you have a condition holding the reserve matters to the parameters plans, even if they don't set out the precise layout, that would have the same effect, presumably, if in that parameters plan you had certain areas that were developable and certain that were not, say for landscaping or something.
Indeed.
Yeah,
I think so. So acting inconsistently with those parameters, I think, would probably get you to the same point. What's interesting about Hillside, of course, is that because of how old the planning permission was, we were way before. I think we were talking about parameter plans.
Yeah.
So that's what makes Hillside rather rather special and different on its own facts.
Yeah.
But
All right. I think. Sorry, carry on.
I was going to say the key test ultimately is the core test of physical impossibility, and that's the starting point and usually the end point also for answering these questions. Sure.
Well, we're going to give you a little rest now, Gwion. Hope you appreciate that. James and Sasha, on the LERB issue, I was interested. Someone's asked, why is it the case that the LERB may change the position that's established in recent case law that you don't necessarily need a strategic environmental assessment of national policy? What's the reasoning behind it?
Well, the reasoning is that one of the requirements for something to be subject to SEA is that the plan or programme is required by various things, including legislation. Now, there would be no change if the European Court had interpreted required as meaning required, but the European Court, in fact, interpreted required as meaning regulated. So long as a policy, a plan, or a programme is regulated by statute, that brings it within the scope of SEA. And the argument that won the day principally in the Friends of the Earth case was that the MPPF was not regulated by any statutory provision. There was nothing that regulated it, which is correct. There is nothing that dictates how you make the MPPF or what its content should be. Contrast now what the government is doing with these national development management policies. They are regulated by statute. They deal with how you make directions for them. So I think that alone could change the reasoning and mean that the MPPF certainly is subject to SEA. Query also whether something in the PPG could be if it was also a development management policy, national development management policy. So I don't know if anyone's thought about that on the government side, but I think they are opening up something that's going to cause them some real problems. Unless, of course, they just abolish SEA, which obviously, if you look at the bill that Sasha covered, the EU law revocation bill. I mean, if you get rid of it all, then it doesn't matter. But if you keep it, then you've got an issue, I think.
Yeah, sure. I mean, it always seemed a bit arbitrary to me that point about whether it's regulated or not.
Yeah, I mean,
whether it's to SEA, but yeah, it's in the wording. But okay. We're getting to the end. We've got time for one more. Quite a few of them will just come in. I was getting one point I think interesting again in Sasha and James's talk about heritage and heritage assets and how some are having more prominence now, likely to get more prominence. But you highlighted it leaves a slight anomaly of the settings of conservation areas which aren't specifically referenced in the Section 72 existing or proposed to be referenced specifically. Any thoughts on what status they might end up having? Or
no, I mean, it doesn't affect the fact that you would have to look at the setting of conservation area in policy terms, but it would certainly be an anomaly because it would be the only aspect of heritage assets that didn't have statutory protection would just be the setting of conservation areas. I don't know why. I mean, I know that in a way the setting of conservation area is quite a difficult concept because of the nature of a conservation area as opposed to a building or an ancient scheduled monument. And I don't know whether it was just felt too difficult to go down that line. But we do have to look at the settings of conservation areas. And if that's the case, I'm not sure I understand why they should have less statutory status than all the other heritage assets that have now got that statutory protection. I can't see a reason for it. Maybe it's just an omission, but I don't know. Maybe there's a logic. I don't know.
Yeah, because I think it wasn't settings of conservation. It was settings of AONBs that was given more prominence in one of the most recent changes to the MPPF, wasn't it? Rather than
it was, yes. Yeah. They changed the wording around setting of AONBs. Yeah, in 176, I think it was.
Yeah.
But no, I mean, there is still obviously, for all of the documents you have to look at for heritage and the guidance notes, you are still going to have to look at the setting of conservation areas. It's just that weirdly they won't have statutory status, whereas every other setting of every other heritage asset will. What that means in practical terms, I do not know. I don't know where that will take us, but it is a strange situation to be in.
Yeah. Well, thanks everyone. I think we've overrun a little bit. Thanks everyone for attending and sticking with it. Another question we had was, are slides being provided? I'm pretty sure they are. I think you'll get a link fairly shortly after the end of this with the slides and with the recording. So thanks very much for attending, and we'll hope to see you all again soon. Thank you.